Hi, hello. Welcome to Telugu NRI Radio Facebook live on immigration, US immigration on every Wednesday, 6 p.m. Central Time. Yeah, last couple of weeks, Lucas is very busy to apply the CAP 2022 H1. Yeah, is a lot of good news coming up today, and the first we can discuss about CAP 2022 H1. We know everyone know the result is out. Whoever got picked up first says congratulations, but the rest of keep it a little bit hope. Maybe the second round of maybe in July or maybe August, whatever the leftover numbers. But the probability is very low. But keep hope and move forward. So now we will welcome to Lucas today's show. Good evening, Lucas. Welcome to Immigration Webinar.
Hi, Venkat. Thank you for having us back and being patient with this as we went through all these CAP cases the last couple of weeks. It was a bit of a rush.
Yeah. So, Lucas, I have a question about, do you have any guess number how many application filed this CAP 2022?
As of today, I don't have official numbers from USCIS. I do know, both speaking with other attorneys, and but obviously with the number of cases we filed from our office, we see across the board there's about a 30% selection rate, which means last year we were right at about a 52% selection rate. So you can just, doing the math, you can see there's a delta there of about 20%. So there's quite a few more cases that have been filed. And just, I want to reflect what you mentioned earlier. Keep hope if you weren't selected this go around. We will have another selection in August. And there is really good hope, I think, if you weren't picked this time, that you'll be picked in the future, in the sense that I believe there's a lot of duplicate filings that, some people made. So obviously, if you're selected more than once, you're only going to choose one selection to file. And so those unused selections will go back to the quota, where hopefully we'll have better luck in the second go around.
Okay. Just you said is a duplicate is one of the scenario. Apart from this scenario, do you give any other scenarios will add numbers leftovers?
No, those numbers were already calculated prior to running the current lottery. So anything that was revoked, unused, or anything else goes back into the pool for the general quota lottery. So we don't really have actual data as far as like the number USCIS determines is, goes back in and increases. So what this means is you have the standard 60,000 that are set at a reserve, but, USCIS could add to that. So let's say last year, if 500 cases were revoked that were previously approved, then those 500 cases would go back. And when I mean revoke, I mean USCIS would maybe revoke an approved case based upon, a mistake by the officer approving the case, maybe a later finding of fraud or misstatement of fact or something like this. So, those numbers aren't typically published for the public.
Okay. Lucas, here, I observed the new application. So last year, we applied for CAP 2021. All our application got adjudicated or still pending, where we were the last year CAP?
So the last year selections, so anyone who was selected this year, same as last year in the first go around, we have until June 30th to file the petition. Typically, for all my cases that were filed prior to last June 30, all those cases have been approved and there's nothing pending. I have maybe 2 or 3 cases that are still pending that were filed from the second batch, which we have until I think November 30th to file. So some of those are in regular processing, and they're still just it's a first in, first out system. This year there's a little bit better processing in the sense that last year there was two main service centers that we used. We had Vermont and we had California. This year, when your selection's made, the service center is going to be assigned to the selection notice. So now I've already seen, Vermont, California, Nebraska, Texas. So they're going to spread out more to additional service centers to help, lighten the load so we can get faster adjudications on all these CAP cases.
Okay. So I think as per Trump administration, a travel ban until March 31st, 2021. So what do you think? Consulate will open for the first visa at a process?
So what you're referring to is the presidential proclamation 10,052. And so
Yes.
what that was limiting certain non-immigrant visa holders from getting stamped to come to America. So in essence, if you already had the H1 visa stamp or a J1, you could still arrive and come to the United States. This process was done to not only, for safety with the spread of COVID-19, but also the Trump administration did this as a way of, quote unquote, of protecting the American worker. So Joe Biden, obviously, his administration is not seeking to extend this proclamation. So the term that's often used is sunsetting, where we're just going to let this expire tomorrow. The consulates will go ahead and continue making appointments. We've had clients that have been able to be stamped through exceptions to this presidential proclamation or by the petitioner or the petitioning organization being a member maybe of the U.S. Chamber of Commerce, where they're exempt from this proclamation by a court order. So, I know a lot of the slots are already booked quite quickly, and, the slots are still going to be, pretty much high demand in the next few weeks to months. And, I know a lot of people are excited to be able to have the opportunity to go home and visit, but I would just, recommend making sure that you're able to book a slot and maybe plan everything accordingly before you make that booking for the flight.
Yes, true. I've been seeing a lot of a demand for visa interview. Slots are very less, but seeking most of the H1 or whatever the visas, interview seeking persons are more. So even we observed the consulate or cancel the visas and saying that you can reset schedule for next available time. But after this March or maybe April 1st, might be change the process and will get everyone the slot. Everyone get the slot for the visa interview.
There's also, remember, a lot of the Dropbox qualifications were expanded. So if you've already had an H1B visa stamp prior, when you're going through and filling out the DS-160, it will tell you if you qualify or not for Dropbox. So there's quite a few people that qualify for Dropbox that didn't previously, but I mainly get most of the queries I have are from people who recently changed from being a student to H1, and they, are eager to go back home and visit family, obviously being away for numerous years. And, that's where we have to be careful. Some people also have been choosing other consulates based upon availability. And I just want to leave a word of caution with that, some people travel to Delhi or Mumbai to get the stamp if the slot's there. And, there's a different, process that goes along at each consulate, right? So Hyderabad, Chennai have a high volume of H1 interviews and stamps. And so they're more familiar. It's more of a smooth process. If you go to another consulate or another country, even just be prepared that you might have a 221G, which would be like a request for additional information before your stamp is issued. So just be mindful of that when booking your slot.
Okay. Lucas, here one question about Dropbox. The criteria is the same consulate and the same the visa category, the previous what it was. Here, the most of the question coming from, let's say, if any H1 applicant lost H1 visa stamped in Mexico, now if he trying to schedule a Dropbox in India, it's showing as eligible for the Dropbox. But do you see any potential issues for changing the consulate one country to another country? Will get any kind of RFEs or 221Gs on this kind of schedules?
You shouldn't. And if you're able to go ahead and go through the DS 160, it will tell you if you qualify or not for Dropbox. So if they determine you qualify, it shouldn't be an issue going ahead and doing that. And you have to remember the purpose for this expanded criteria for qualifying is that we're in the middle of a pandemic. Hopefully we're at the end of it, but we're still in the middle of a pandemic. So we don't want exposure unnecessary to other people, especially people working at the consulate. And B, we want to make sure that, if there is emergency appointments or emergency usage, that whatever capacity is available is reserved for emergencies. So that's kind of like the Department of State's guidelines there, what they're trying to do, to help alleviate any type of logjam. For in the past you'd be required for the actual appointment, but now you might be required just to do a Dropbox.
Okay. Oh, yeah. Is any maybe a lot of people are looking for the H1 stamping. Do you have any recommendation, or maybe before scheduling to the visa? Already you told, but is anything else you want to share to all viewers?
Obviously, pandemic or no pandemic, you want to make sure you communicate with your employer, the petitioner. Make sure that you have your everything in order, your payroll, your consular packet, any kind of client supporting documentation. And just because USCIS has relaxed some of the requirements for when you submit your H1B amendment, extension, or CAP petition, does not mean that the officers abroad aren't going to seek additional information like a client letter. So what this means, even though we can get your petition in the United States approved without client letter, the consulate officer might still request that letter. So just be prepared and be patient. If you do receive a 221G, it's just, it's part of the process. And, you just want to try and make sure you plan it accordingly for anything that might happen. And, just be patient with the time.
Yeah, thank you. Thank you, Lucas. So we can go for next topic, the proposed immigration bills. So what are the proposed, maybe, you can share, is good news or bad news?
At the moment, I still say good news. And again, like what you and I've discussed, maybe for the past 3 or 4 months when we were floating the idea of comprehensive immigration reform, it's, if you put everything into one bill, it's either, all passed or all fail. That's a lot of, risk in that process. And the Biden administration has already done proposed a few bills that the House has passed in the sense that it's a piecemeal. Piecemeal means I'm find 4 or 5 and identify 4 or 5 different categories I want to, fix or approach. And these are all different categories within the one main bill that you and I reviewed maybe 2 months ago, Venkat. And what they'll do is, like we have one for the Dreamers that was put through, and we have another one that was passed by the House for, farm workers. So, at the moment, both of those are now with the Senate, and that's where the true negotiation debate comes in. The way this process has been established and set up is, it really bodes well that, if anything is passed, I think the compromise would be saying like, hey, we want more high-skilled workers here in the United States. We want to address this. We want to make it more attractive, or maybe smooth out the process, erase the backlog. I think that's easier to negotiate with the Senate than maybe providing just widespread relief across the board. So I hope everything gets passed, but if it doesn't, I think at least this bodes well for everyone who's in the EB backlog at the moment.
Yeah. So just you told that there's two bills got approved in House for DACA and Dreamers. So what are the chances to pass the bills for employment immigration process?
I would say if you were going to rank all these different aspects of the comprehensive immigration bill, that I think that obviously on one end, on the highest probability is going to have to be employment-based immigration, in the sense that if anything passes, I believe it's going to have to include that, addressing the backlog. And then obviously going down the least possible probable way of the part of this bill getting passed would probably incorporate something to do maybe with people who have temporary protected status, or often referred to as TPS, having a pathway to citizenship. So, that's very unlikely to pass, very much, going to be challenged by the Republican Party. And I think, on the other end of the spectrum, we have employment-based, which I think if anything does pass, there's a very high probability it's going to be focusing on the EB backlog.
Okay. And it means, can you give any rough estimation when this bill's going to be come to the floor, and maybe it will get in floor and process?
Well, so we have to remember there's two bills that have already passed the House, and a similar, bill has already introduced in the Senate. And so now we have to wait for, the Senate to move forward. And obviously right now, the way everything's established with the rules in the Senate, there's no real guarantee of if or when any action might occur on these bills, due to the, each house, each part of the Congress has their own set of rules and procedures that they follow. So the current rules and procedures that are in the Senate allow, a lot of power to, right now, the minority party, the Republicans, to control what comes forward and, how things move. So I can't really tell you a time frame on that, but I would think maybe by early summer, we'll have more clarification as far as when we're going to see additional bills proposed and pushed through. And having said that, I want to kind of bridge over to some more good news. We had our first update for this fiscal year in regards to, what visas are available and what the future might be. So we had a similar statement last year, which is what you and I were talking about leading up to last October, when all these, the visa categories moved rapidly for employment-based. So this year, the report is, because of, the pandemic, we're still not seeing many family-based petitions or visas being allocated. So all those unused visas are going to be reallocated, just like last year, to employment-based. And so based upon those comments, last year was unprecedented in the amount of visas available and reallocated. This year, they're expecting the number to even be greater. So I don't know if USCIS is going to allow us to use the filing dates again until the end of this fiscal year, which will be October. But the final action dates have moved quite rapidly, and we've seen it kind of EB2 go through 2010. It's tracking quickly. EB3 is also moving quickly. It should slow down with however many people start downgrading to take advantage of that final action date. But we saw 2014 as a filing date for EB3 last year, and I can see that advancing rapidly also, and maybe into 2015, 16 this upcoming year in October.
Is a filing date or final action date for 2016?
Filing date.
Filing date. Yeah. Just we hear the Department of Status release the unused numbers will go at for the next fiscal year, but roughly is more than 100,000 or 150,000. I'm not sure.
It's greater than 150K.
Okay, it's good. It means whatever we expect, whatever it happened on last October, this October also move faster. Maybe EB2 and EB3, it moved a couple of years. So here the question, it means everyone is ready for the next October process, or they are ready and they are collecting the information, what needs to be done, or be prepared for apply the 485 adjustment of status. But we hear by this end of year, September 30, whatever the filing date on October 2020, let's say is EB2 is May 2011 and EB3 is December 31st and 2014. We'll get these all numbers to final action date.
So that's a very good question. There's formulas that are used for filing date, and then the final action date obviously is the visas allocated for whatever petitions are there for people to file. Now, when you're taking into account a lot of the data and formulas that you utilize to make these dates, they obviously you would have to look and see how many petitions have been filed. So just because there's 100 I-140s approved with a priority date of 2000, let's say March 2010, it doesn't mean that all 100 are going to be utilized. So there's, maybe only 80, 75 file or have the ability to continue processing. Obviously, they would have to, maybe some people go back home. They're no longer here. Maybe they're not able to get a supplement J. There's a lot of different areas affected. What I can recommend is, in anticipation of any filing dates moving, now's the time to go ahead and start planning, because if you have to get a new perm certified and you have to file a fresh I-140, that's going to take, right now about 9 months, 10 months from start to finish to get that done. So, you really need to plan right now instead of waiting for the window to open and then take action, because by that time you're going to miss the opportunity.
Yeah. I hear a lot of question about the downgrade process. So after May 2011, all are processed in downgrade. Let's say the number are going very fast. The final action data numbers are going fast. Our downgrade I-140 still is pending. Do you recommend to process a premium process?
No, depending on what your priority date is, it's something I would be careful as far as looking at. What I would recommend is, looking to see what the final action date is. Go ahead and move forward with that and see, where you're at. If your final action date is current with your visa category, depending on whether or not you downgraded or not, that's going to have a key indication on how fast your case can process. But you have to remember, so your adjustment of status is not going to process until that final action date is current. And what's often been very frustrating in the past is we might have someone who right now has a priority date of February 2010. And let's say next month, the final action date goes back to January 2010. Well, that means everything stops on the processing of your adjustment. So you have to wait until the final action date becomes current again for your, your GC to continue processing. And in the past, it wouldn't be so drastic, if something like that happened. But now, since all these employment-based visas require interviews, it's something that's going to impede or delay the process. Right now, more, bottom line, things are moving in a positive direction, but there's still, certain log jams that can occur.
Okay. So what are the chances to move beyond 1 year or 2 year final action date? Is there any chance for this current situation and scenarios? Based on that, let's say if any H1 applicant apply the 485 adjustment on priority date 2013 December, but final action date still in 2010 September. So what are the chances to jump 2010 to 2013?
Well, so the chances of it jumping that far is still not very good, because you have to remember how many other people already are taking advantage of the downgrade. So because of that, I mean, there's people pretty much, you have to imagine like you're in two lines. And so some people in one line are, jumping in front of you into the other line. What I would recommend is continuing what we've discussed in the past is if we have this comprehensive immigration reform addressing this backlog for adjustment of status, if it's passed, it's going to provide pretty much immediate relief. But the bill is won't take effect typically for 6 months after it's signed into law. So, it's still a couple of years as far as the process if everything goes well. It's not something that would be done from what I would estimate. It won't be something that would happen overnight, so to speak.
Okay. So it means we need to act based on your priority date. Let's say priority date is maybe 2011 June, July. Maybe there is a chance to move end of the year or maybe the next year. But whoever the priority date in 2014 and 15, maybe they do have some kind of time to take a decision to apply the priority date or not, right?
Correct. And again, so when we first spoke about, everyone last fall applying for adjustment, utilizing the filing date, it's not just the end goal of getting the GC. It's also protecting family, right? So maybe in this new bill that's proposed, we have something where children do not age out. So maybe one of the requirements would be if your case is filed, and even if it takes a few years, as long as that was filed, it might prevent the kid from aging out once they come of age. So, there's a lot of things, it's always a good idea to have your foot in the door, so to speak. Even if the process takes a little bit of time, at least you're in process, it's moving, but it's, everything with immigration it takes years of planning, not weeks, days, or months.
Okay. Lucas, visa bulletins and predictions are already most of points we discussed now, but do you want to share any additional information about upcoming visa bulletins and predictions?
I think based on what we heard, it's very much extremely positive report that came out this week. Again, there's no guarantee of what might happen, but based upon everything we're seeing, looking forward optimistically, I think this fall there's going to be a large jump in the filing action, or the filing dates, and also the final action dates for the GC process. So I would, if you have a priority date in 2015, maybe even 2016, go ahead and be prepared, have everything ready. Make sure you coordinate with your employer, kind of get that process in place. So when October 1st comes, you have everything set and are ready to file.
Okay. Lucas, next coming to 485 adjustment of status updates. So we applied about an October filing. I think we hear the USCIS is accepting refiling, right? Already we discussed in a couple of weeks ago. The USCIS is accepting all kind of rejection, or is any certain kind of rejection they are taking to reprocess?
Well, that's a good question. From what I understand, is USCIS is pretty much accepting across the board all cases that were rejected. Most common rejections, I think, include not selecting, I think it was number 9 or so on the application for derivatives. But even filing fees or any other deficiency with the case are being accepted. And one of the main arguments to say this is to say, look, we filed the case in October. We didn't get rejection until February. So even though, the applicant made a mistake, or the attorney representing the applicant made the mistake, if we would have known that the case would have been rejected within a reasonable time, we could have resubmitted before the final action date, or the filing dates expired, so to speak, with USCIS. So based upon that, there's that's pretty much the case moving forward. It was a significant delay with USCIS for the rejection, and that's why most of these cases are being accepted again, even though the filing date is not being honored at the moment with USCIS.
Okay. So here, the 485 adjustment status, now in process, let's say the priority date is 2013 December. We know that in initial stage, it's not required to submit the medical documents. Let's say, just in case, but hypothetically, the filing action date moved to the 2013 December. Is there any chance to submit the medicals in between?
No. So what you don't want to do anything unless you receive a request for evidence. And sometimes you'll receive a notice of deficiency where USCIS will say, okay, you don't have a medical, but your interview date is this day. Bring the medical with you and hand to officer. That's very typical. And if the officers really need the evidence before an interview date, they'll just issue a request for evidence, and then we just mail it in. If you mail something in without a request for evidence or some type of notification, it typically will not, make it to your file. So you just need to be patient and wait.
Okay. The same scenario, let's say I reiterate the question, reframe the question. Let's say the same priority date is 2013 December. We applied document. We submitted the document along with the 485 adjustment of status file. Let's say the priority date, maybe the filing action date maybe will come after 2 years or 3 years. The question is, how many days the medical will validity for accept the USCIS?
So the medical will expire depending on whenever you submitted it. So typically right now, it's valid for 1 year. And then afterwards, if that's why I always recommend, especially if you have a family of 4, getting a medical can be very expensive. And until it's actually required, you're going to have to redo it again in the future. It's just, more or less money wasted. So typically what we recommend is just for this type of situation where your priority date is still somewhat distant to the final action date, just go ahead and submit just the application itself. And then when it comes time closer for the visa to be issued, we can go ahead and get the medicals done at that time.
Okay. The same now. It means nowadays the reason nowadays USCIS is not allowing to the visa interview, GC visa interview, it directly adjudicated based on the all information. The same scenario if filing date, final action date is coming up, we did not submit the medicals. How USCIS will request for the medicals?
They can do. They'll send either a notice of deficiency, or they'll request you to have a request for evidence to mail it in.
But I saw somewhere else we can file is the intra filing.
But there's no point in so whenever you have a medical that's coming up, the officer will issue the request for evidence or a notice of deficiency. At that time, you would take action with whatever's recommended. If you do any type of intra filing, there's really no purpose to it because no one's working on your case at the moment, you see. That's why I would recommend you just wait until you're being notified. That's usually the standard operating procedure for something like this.
Okay. So USCIS will notify direct petitioner or lawyer, the both?
The applicant. Yes, and also the lawyer. So typically, it could either come on a pink sheet or it could come on a white sheet.
Okay. So the same on October 485 adjustment of status, still most of the applicant did not get the biometric date. Mm-hmm. Do you see when is any progress on that one? Is any backlog or what is the status for?
It's a huge backlog. So the USCIS uses a FIFO system, first in, first out. Now, if you were fortunate enough to only have to file with the supplement J, which means you were EB2 and you could go ahead and file, most everyone with EB2 has already had the biometric and already probably received the EAD. If we had to file a downgrade with the adjustment application, that's been a delay because there's been so much demand for that type of filing. So just the processing delays with that, along with whatever your local office is seeing as far as appointments for biometrics, there could be delays. And, I think that's being addressed right now too by AILA. We're looking at that. Also, I would expect hopefully within the next month that we start receiving quite a few appointment notices. I actually kind of am getting worried the delay is this long because, once you get the file, if we filed your application in November, usually, typically your employment authorization is going to be for 1 year. So you might actually end up getting your card and only have it valid for 2 months. And then, you have to file extension again. So, hopefully they speed up the process and work out whatever problems they're having.
Okay. So I think one of the law firm filed a petition in court about H4 and L1 biometric process to remove the biometric process, I think. Mm-hmm. Do you have any information on that one?
Yes, so it's very good news. Last week, I think exactly last week, a law firm filed a lawsuit in DC, and it's kind of they're looking to rectify the processing delays that are affecting so many people, specifically H4 EAD. at the moment. We've had some applicants who've been pending, 5, 6, 7 months without receiving their approval. And, it's impacted a lot of families where the person with H4 EAD has a job. Then when EAD expires, you're not permitted to work on the receipt. And this causes, maybe interruption in someone's work and destabilization for family income. And, it's something that needs to be addressed and fixed. Hopefully, one of the solutions I think that would, fix this problem is if the biometrics requirement for H4 EAD or L2 EAD or any of these other dependent categories, if that requirement was removed, that would speed up the process significantly.
Yeah. Excuse me. Yeah. So I think if remove the H4 and L2 biometric, it potentially improve the 485 adjustment of biometric too.
Mm-hmm.
All right. So how long it will take for maybe judgment or maybe about the H4 L2
for the lawsuit?
Yeah.
Typically, whenever you sue the government, it's going to be anywhere between a month to 2 months for the government to really respond and take part. Maybe they'll file a motion to dismiss, and then basically that's the whole linchpin of the case is at that moment to determine whether the judge determines whether or not to dismiss the lawsuit or not. If the lawsuit's not dismissed, then there's more significant negotiation that can happen with the government to maybe see what issues there are. In some rare occasions and circumstances, you can usually, if the lawsuit's filed, maybe discuss the case with the U.S. attorney and find a solution before going through certain other procedural steps. It is somewhat rare for that to happen. And obviously, since this is on a large scale, I would foresee this really, the government coming back and filing a motion to dismiss. And then, based upon what the judge determines at that point, we would still need to see what negotiations would take place if this motion's denied. So overall, if I were to say a timeline to see how things would move, I would still think at the earliest to be midsummer before we see a solution to this problem. But I'm pretty hopeful. Obviously, the people who filed the lawsuit have had some tremendous victories over the past year suing USCIS. So they have a pretty good probability of prevailing on this one as well.
Okay. Yeah. Lucas, we have, we got a couple of questions on Facebook and the YouTube. The first time taking one question from Raghuram. What happened if we travel on advance payroll without I-140 approval in case of in EB3 downgrade scenario?
Well, as soon as you're issued advanced parole, you can travel, or whatever you need to do. That it's not dependent upon whether or not your I-140 is approved. Now, if your I-140 is denied, obviously your adjustment application would soon after be denied, and that would include your EAD and advanced parole document. So, as a backup plan, you'd want to make sure you would have maintained your non-immigrant status, still have your H1 or H4, whatever it might be, and then make sure if the advanced parole is not there, at least you can re-enter with a fresh stamp if you need the stamp.
Okay. I think Raghuram asked the second question, but also what happens to EB2 I-140 when we travel on EB3 I-140 advanced payroll? I'm not clear this one, but
yeah, nothing happened. I mean, it's independent of those. So whenever you file for adjustment, you also have the opportunity to file for employment authorization and advanced parole. All the fees are included as one, but all the applications are not dependent to process as one. Now, having said that, the linchpin is the I-140 that you filed the adjustment application with. So if that I-140 is denied, obviously the adjustment you filed would be denied, and also the employment authorization and advanced parole. So you'd have to be careful with that.
So in this case, Lucas, let's say I-140 got denied. The immediate after the 485 adjustment will deny, or it will wait until the final action date and the visa, maybe the officer will check the status, what is the I-140 is approved or denied, then after they rejected or.
No, it would be denied as well, pretty much within a few weeks of the, if not days, of the I-140 being denied.
Okay, but in this case, we have to back a plan with the H1B status.
Backup plan, correct. That's why you want to be careful with that. Make sure that you protect that as much as you can. And all this comes to see, also in the future how fast these final action dates move. Maybe you can plan accordingly to make sure that you're preserving your non-immigrant status as long as possible.
So here, one question, Lucas. The most of the 485 adjustment applicants are asking when they get the advance payroll and authorization card. Are you recommended to use immediately, or they need to wait until I-140 approved, then after they can use the advance payroll and EAD for further process?
I mean, I would recommend, especially for EAD purposes, if you're planning on moving on from H1, make sure the I-140 is approved before you make such a big decision, because if anything bad were to happen where I-140 is not approved, you're obviously going to lose that, and then you're going to have to be in some other non-immigrant status to continue living in the States and maybe even working in the States, depending on what your current visa category is or non-immigrant category.
Okay. From Facebook, we have one question about adjustment of status. Have you seen here any update on resubmission of AOAs, rejected cases because of improperly filled application? I mean, USCIS accepting those cases, even though priority date is not current. I think we already discussed about it.
Yeah, but it's been a case-by-case basis. I've heard from a few people, the submissions were accepted. But again, it's something each officer, when it's resubmitted, or that would be scrutinized independently. It's not saying that everyone who had a rejected case can resubmit. It is a case-by-case basis.
Okay. So we have a Ravi on phone. Ravi, do you have any question you want to ask? Ravi, do you have any question to ask Lucas?
Hey, can you hear me?
Yes, Ravi.
Yes. Hi. Hi, Lucas. I have a question about, the probability of I-140 for premium processing, and how long we need to wait if we want to change the employer, how long we need to wait after getting the EAD approval or I-140 approval?
Hi, Ravi. So thanks for the question and participating with our Facebook Live here. I would recommend, if you're thinking about transitioning to another employer, obviously, the magic number here is 180 days, 6 months. So once I-140 is approved, your current employer would have within a window of 6 months, they can still reject or withdraw that I-140 approval. After 6 months, you still have the ability to port from one employer to another. So if you know that your current employer will not withdraw the I-140, you can still port over to another employer, and after 6 months of your adjustment pending, if you need to file a supplement J, your new employer could just go ahead and file a supplement J on your behalf.
Okay, so the 6 months after I-140 approval, right? Not after getting EAD.
Correct. So there's two separate 180 days here we're talking about. After you file your adjustment, which was back in October or November, you have 180 days or 6 months you can port to another employer since your adjustment's been pending. But that's different if you're on a different note, your I-140 can be withdrawn after it's approved within 180 days. So you want to make sure after your I-140 is approved to start the clock at 180 days from that point moving forward, just to protect you and your family.
Oh, okay, got it. Okay, thank you. Thanks, Luke.
Yeah,
Thank you.
Ravi. Yeah, Ravi, thanks for call. But if still you have any questions, maybe you can send an email to info@bgimlaw.com. So this is very sensitive information. Maybe if you feel that, you can send an email to Lucas, and Lucas will reply.
Okay, sure.
Yeah,
Thank you. Thanks, Ravi.
One more phone number added, Anugu. Anugu, do you have any question? You can ask.
Oh, yeah. Hi, are you able to hear me?
Yes.
Yes.
I had to go.
Okay, yeah. Yeah, thank you for your time, Lucas. So my question is, so currently my employer filed my 485, and we filed in October. So I'll be completing 180 days by end of April.
Mm-hmm.
So this is not a downgrade 140. It's a straight EB3 140. So my question is, so after 180 days, so can I change my location, my current location where I'm working? I want to move into a different state. So does it cause any issue in my 485?
No. So the very good question.
But I'm going to stay with the same employer.
Sure.
And same job, but it's a different location.
So I have this question come up quite a bit, and it's thank you for sharing that with us. Basically, if whenever a petitioner files for I-140, we have a prevailing wage for a certain geographic location and where the proposed work is going to occur. So we have to remember I-140 is looking at future employment. Where are you going to work once you have the GC in hand? Okay. So if your employer used their own address or where your project was before, that's something that's for once you have GC in hand. In the meantime, if you go from one place to another, there's no requirement to update that. It's just in the sense that when your final action date becomes current and your GC is approved, that's where the work location is supposed to take place. Does that make sense?
Oh, yeah, sure.
So are you on H1 right now?
Yeah.
So
yes, I'm on H1.
So the only requirement that you really need to take care of right now, based on what you told me, is going to be that, obviously filing an amendment if you're moving from one state to another. But, I need to know more specific details about how your case was filed for more of a definitive answer. But just based on what you've said and, the simple facts that we discussed, everything should be fine for the GC process. Okay.
Yeah. Thank you so much. Yeah, thank you.
Thank you for calling.
Thank you, and thank you for calling. Lucas, we will take another two questions from Facebook. One is Karan. Already you explained about the medicals, but still asking the same question. When I filled I-485, I did not submit the medical I-693 document, but I have I-485 receipt. Can I send the medical now? Sort of enter file, and how to do?
I wouldn't recommend starting that process yet. Just wait until you're notified, because no one's going to actually actively work on adjustment of status application until your final action date becomes current. So if we're still a year, 2 years away before anything could happen with your case, it's just, a kind of wasting time and money. Also, things change, okay? And what do I mean by things change? Well, when everyone here who's part of this program, when we filed back in October and November, we had to also file the 983 form with the credit reports, assets, liabilities, all this laundry list of things we had to include. Well, now that's no longer required. So by the time, it doesn't mean someone's going in the file right now and taking all this information out. What it means is when it comes time to work on the case, when the final action date becomes current, that information is going to be discarded at that time, and it's not required. So the same thing could happen. Maybe in the medicals, by the time it's time to adjudicate your case, maybe we need to include vaccines for COVID-19. Maybe there's some other additional things. Circumstances change and forms are updated. There's a lot of stuff that can happen between now and when that's actually required. So I would just recommend just wait. It's not going to hurt anything to wait. It's not going to delay your case or anything else.
Yeah, thank you. Karan, I think you got the information from Lucas. Lucas, here one of the interesting question. The H1 I-94 expiring end of April 2021. His employer is going to be submit the application maybe next week, maybe first week of April. I think the receipt numbers are delaying. His question is, can I work without receipt number after the expiry of visa I-94?
So very good question. Depends. So I can tell you what I know. Typically, I don't know which one of the 4 service centers you're going to where your case will be filed, but there has been significant delay with Vermont. So for this extension, if you file the case, if you have the opportunity to file a premium, I would recommend that. Texas, California, Nebraska are all pretty much operating at about a 2-week window for regular process to get the receipt. But Vermont is delayed quite a bit. And to answer your question is yes, to officially work, you have to have your passport and I-94 for your I-9 form. Whenever your I-94 is expiring, even if you don't have an approved H1B I-797 in hand, you can still work for 240 days on the receipt. So what your employer has to do is take that receipt and do a Section 3 rehire on the I-9 form to continue, working. So just because it's mailed doesn't necessarily, mean that you get to continue that process. So I hope that answers the question. As far as the technicality goes, you do to verify your employment and do a rehire appropriately, you do need to have the receipt in hand, or at least have the receipt number.
Okay. If we have the receipt number, then we can continue to existing employment, or else we need to rehire process. Right? That is your saying.
Well, technically, as far as the I-9 is concerned, when you're establishing that, you would need that information. But as far as USCIS is concerned, make sure you mail this application or petition before your I-94 expires. That allows you to continue working 240 days. Hopefully, you have an answer prior to that. And make sure you keep track of that. A lot of people who their employer makes them file in regular process, they lose track of that date. And that's where people get in trouble, where you have to stop working because you're pending an extension. And then, if your case gets denied for any reason, your I-94 is expired. That means you can't either change employers and start working, or even refiling a case with the current employer because I-94 is expired. So it would require you to depart and re-enter to have a fresh I-94 to continue employment.
Okay. Lucas, we have another two questions. One is from Srinivas Gudipati. Hi, Lucas. What do you think on GC interview waiver? Are they going to waive for all?
GC interview in the sense for employment based, or
I think employment based.
they could, and you have to remember also right now we're at nearing the end of the pandemic. So as soon as operations resume, at each service center or at each field office, they'll schedule the interviews appropriately. Obviously we still have. I've had family-based interviews as recent as last week, and I don't even go to the field office right now. We're permitted to have attorneys being contacted by phone. So that's more or less how we've been doing things. And I know they're limiting how many people come in. So, I would expect maybe in the next couple of months, things are going to go back to normal. And, if you're scheduled for interview, then it's highly more likely, for our batch that filed last October, that interviews are probably going to be required.
Okay. The same on follow-up question from Ambati. He filed 485 filing on October 2020. Any possible to avoid the interview for priority date in 2010?
2010. So tell me again.
I think he filed the petition October 2020, 485. Any possibility to avoid interview for priority date in 2010? But here we need to get EB2 or EB3. EB3 almost in September, right? September priority date.
Yeah, because the final, even the final action date with EB2, depending on where it went in 2010. So if we had a little bit more information, maybe we can speculate on that.
Okay. Yeah, the Ambati, if you're seeing, maybe you can send an email to info@pgmmlaw.com and get more information from Lucas. Thank you. Thank you very much. Lucas, I think we're done today. So we discussed a lot of questions and information. Today is very productive and informative for all across the board. The next coming weeks or months, and maybe next year, we will see the more GC moving. So hopefully, it will go the same direction. What will last year, October 2020.
Yeah.
So yeah. So I'm ending the show today. Do you want to share anything apart from what we discussed today, Shishan?
No, I just want to thank everyone and appreciate everyone's participation today. I think what Venk has always said is this is a platform for the community. So the more participation we have, the more assistance it is for other people, maybe with a similar situation as yourself. So we really appreciate your questions and comments.
Yeah, thank you. Thank you, everyone whoever participated today, and whoever called and whoever raised the questions. So we are encouraging to everyone. We are open YouTube comments and Facebook comments and conference call. Maybe you can choose the best way to share your question and get more information from Lucas. So we are trying to provide more information and accurate information on U.S. immigration system. Maybe you can share your topic, we can discuss, and if you have any sensitive questions and sensitive information, maybe you can send directly to info@bgimmlaw.com and get more information. So thank you very much. Thank you, Lucas. Bye-bye. Until next Wednesday, same time and same platform. Bye. Good evening and good night.